starting in 5 seconds. Going further, we have heard Mr. Tushar Mehta, Learned Additional Solicitor General for the Union of India, Mr. K. Radhakrishnan, Learned Senior Counsel, appearing in Interlocutory Application number 94 of 2018 in Writ Petition number 76 of 2016, Mr. Mahesh Jethmalani, Learned Senior Counsel, appearing in Interlocutory Application number 91 in Writ Petition number 76 of 2016, and Mr. Soumya Chakrabarti, Learned Senior Counsel, appearing in Interlocutory Application number 94 of 2018 in Writ Petition number 76 of 2016. It is submitted on behalf of the petitioners and the interveners that homosexuality, bisexuality, and other sexual orientations are equally natural and reflective of expression of choice and inclination founded on consent of two persons who are eligible in law to express such consent, and it is neither a physical nor a mental illness, rather they are natural variations of expression and free thinking process, and to make it a criminal offense is offensive of the well established principles pertaining to individual dignity and decisional autonomy inherent in the personality of a person, a great discomfort to gender identity, destruction of the right to privacy, which is a pivotal facet of Article 21 of the Constitution, compatible to the highly cherished idea of freedom, and a trauma to the conception of expression of biological desire, which revolves around the pattern of outline of true manifestation of identity. That apart, the phrase order of nature is limited to the procreative concept that may have been conceived as natural by a systematic conservative approach, and such limitations do not take note of inborn traits or developed orientations, or for that matter consensual acts which relate to responses to series of free exercise of exertion of one's bodily autonomy. It is further argued that their growth of personality, relation building, endeavor to enter into a live in relationship or to form an association with a sense of commonality have become a mirage, and the essential desires are crippled. It is urged that the American Psychological Association has opined that sexual orientation is a natural condition, and attraction towards the same sex or opposite sex are both naturally equal, the only difference being that the same sex attraction arises in far lesser numbers. This has been concluded in some of the research reports by various research organizations. As such, the petitioners in their arguments have highlighted that the rights of the gay, bisexual, and transgender community, who comprise 7 to 8% of the total Indian population, need to be recognized and protected for sexual orientation is an integral and innate facet of every individual's identity. A person belonging to the sad community does not become an alien to the concept of individual, and his individualism cannot be viewed with a stigma. The impact of sexual orientation on an individual's life is not limited to their intimate lives but also impacts their family, professional, social, and educational life. As per the petitioners, such individuals need protection more than the heterosexuals so as to enable them to achieve their full potential and to live freely without fear, apprehension, or injury in such a manner that they are not discriminated against by the society openly or secretly or by the state in multifarious ways in matters such as employment, choice of partner, testamentary rights, insurability, medical treatment in hospitals, and other similar rights arising from live-in relationships, which after the decision in Indra Sharma vs. VKV Sharma is recognized even by the Protection of Women from Domestic Violence Act 2005 for various kinds of live-in relationships. The same protection as per the petitioners must be accorded to same-sex relationships. It is urged by the learned counsel for the petitioners that individuals belonging to the LGBT group suffer discrimination and abuse throughout their lives due to the existence of Section 377 IPC, which is nothing but a manifestation of a mindset of societal values prevalent during the Victorian era, where sexual activities were considered mainly for procreation. The said community remains in a constant state of fear, which is not conducive for their growth. It is contended that they suffer at the hands of law and are also deprived of the citizenry rights which are protected under the Constitution. The law should have treated them as natural victims and sensitized the society towards their plight and laid stress on such victimization. However, the reverse is being done, due to which a sense of estrangement and alienation has developed and continues to prevail amongst the members belonging to the LGBT group. Compulsory alienation due to stigma and threat is contrary to the fundamental principle of liberty. The petitioners have referred to the decision of this court in Nalsa case, wherein transgenders have been recognized as a third gender apart from male and female and have been given certain rights. Yet, consensual activities amongst transgenders would continue to constitute an offense. Stop.